Good morning. My name is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2018 Harlan Institute Consorts Virtual Supreme Court competition. This is the third match of the tournament, and we have two teams from Greenwich, Connecticut. We have James Heavey and Nick Liu, and we have Alexander Bound and Matthew Weindling. Today we will be mooting the case of Carpenter versus United States. And I now turn over to my good friend and colleague, Julia Silverbrook from the Constitutional Sources Project for her introduction.
Thanks, Josh. We're excited for the semifinal round, and I wish both teams the very best of luck. We're hoping to have a lively round of oral argument today.
Thank you so much. All right, and without further ado, I will turn it over to the petitioners. Nick and James, sirs, you have 15 minutes, and you can begin whenever you're ready.
Hello, Your Honor. I'm Nick Liu, and this is my partner, James Heavey. We will be representing Mr. Timothy Carpenter in the case of Carpenter v. United States today. The collection of Timothy Carpenter's CSLI data from a cell service provider from a period of 127 days was a search because of the scope and sensitivity of the proprietary information and the involuntary access to computer processed transactional data, and was thus unconstitutional without a warrant. Much of previous court precedent regarding Fourth Amendment doctrines like the third-party doctrine, public disclosure doctrine, and content versus non-content discrimination bear little relevance to the unique circumstances of Carpenter.
The facts of the case are as follows. In April 2011, there was a series of armed robberies. One of the suspects was caught and confessed to committing the robberies along with up to 9 other accomplices. He also turned over the names and phone numbers of these accomplices. With this information, the FBI applied using the Stored Communications Act for a court order to receive the CSLI and transactional information from these cell phones. And using that evidence, Mr. Timothy Carpenter and Mr. Timothy Sanders were connected to the crime and were charged under federal law.
First, consider the changing nature of digital information. CSLI data today is becoming increasingly advanced with thousands of data points being collected every day. In fact, according to Washington and Lee School of Law, a data connection is made every 7 seconds, and the cell phone's metadata, including its location and what tower it's connected to, is stored. As CSLI continues to become increasingly revealing and precise, they bear the potential not only to act as essentially a GPS tracking device, but they expose very private details about one's life just by performing everyday tasks on a smartphone. And that's where the line between just business records and something more sensitive is blurred. For the court to haphazardly apply previous precedent without considering the severity of the issue would be irresponsible towards the vast majority of Americans. Next, consider the general and unchecked nature of the access information. The collection of 127 days worth of information would be classified as a search because taking all of these data points together under the Mosaic theory, it is a long-term surveillance which reveals highly sensitive details about one's life. And people have a clear expectation of privacy towards their long-term movements, especially because the data points weren't taken from public locations.
Counselor, if I could interrupt you for a minute. You mentioned the Mosaic theory of the Fourth Amendment. What case established that as our rule within the Supreme Court?
That'd be United States v. Knotts, where just tracking one car trip would be fine, but people expect to have privacy over their long-term movements.
You say Knotts?
Yes.
Was that the GPS case you're talking about?
That was where the police followed a car in public, and it was okay because it was just one time, and he was out in public, and it was reasonable to suspect that he could be tracked by a police car.
Yeah, and that falls under the public disclosure doctrine in the sense that if you are in the view of the public, you lose certain expectation to privacy if you can be followed in a public realm. But it does become more blurred when you start to talk about technological data over the course of 127 days without any limitation on the search.
Yeah, so that was addressing my question. Does a case like Knott's decide Carpenter? Is there a difference between the cell data being used on these phones and a car driving around in public? Do you see any difference there?
Inherently, yes, sir, Your Honor. The thing with the car is that it's totally visible all of the time. And if you were to follow it with a police car, that is understandable as it is in the outside. With this cell data, Mr. Carpenter had on multiple occasions, over 100 points of data per day over the course of 127 days, which is over 4 months of continuous tracking. There was no attempt by the FBI to reduce the amount of search being conducted or to minimize it. The principle of minimization was originally created in the Omnibus Crime Prevention and Safe Streets Act as a way to limit the intrusiveness of wiretapping and other digital searches. While wiretapping is understandably more invasive than the collection of CSLI and transactional data, the parallels between the two as far as technological data relating to the communications of parties in this case, they are treated with similar thought process as far as where they're coming from.
Counselor, can I interrupt you to ask a question? How precise is the CSLI data?
Well, back in 2006, which was when the incident happened, it was not as precise. It was more of a 2-mile radius, but the court has to consider that a lot more cell towers have been put up. And now with CSLI data, we can detect a person's location to within 200 feet.
As well as the fact that there's an increasing number of both cell towers and adults that use cell phones. In 2005, the figure of adults that use cell phones was between 62 and 64%. Today, it's around 94% as far as American adults that own cell phones. It is becoming part of the American identity and one of the useful tools that you use to function in today's society, whether that's maintaining communications with your job or your family. And due to the increased scope of people that use it, as well as the ability of technology, there are now buildings where they will have one cell tower for an entire floor of the building. So it's much more limiting in the sense that, sure, well, you can just see which cell towers he's using, but as the number of cell towers increases, you're looking at much more precise data, and you start to cross into cases that start to look more like Jones in the United States.
Yeah, tell us a little bit more about Jones and why this case, in your view, is similar.
Yeah, basically, CSLI data inherently, when you look at it just like a singular data point, those are just transactional business records that the cell provider legitimately uses to determine which cell tower to connect to. But when you aggregate them under the Stored Communications Act, it becomes much more revealing. They can reveal exactly where a person has moved over a long period of time. And that's why CSLI data, especially today, is basically can serve as a GPS tracking device as seen in Jones.
And to build off what my partner here is saying, in Jones, you're looking at a governmental planted device onto the person where they are physically and solely tracking the location of this person in direct time. Carpenter is slightly different in the sense that it's retroactive tracking of the person. It is without a warrant, and it's using a cell phone, which decided in Riley v. California is an extension of the home in the 21st era. As Chief Justice Roberts said, a phone not only contains in digital form many sensitive records previously found in the home, it also contains a broad array of private information never found in a home in any form. So the court has been looking to increase the protections for cell phones, as well as make sure that the current precedents that they're using are staying up to date as far as advancing technology, the power of said technology.
Counselor, can you tell me what role does the Stored Communication Act play in our decision today?
The Stored Communications Act was used to acquire the transactional records by the Federal Bureau of Investigations. Essentially, if a government entity can provide clear and articulable facts that the information that they're seeking would aid in ongoing criminal investigation, they can receive a court order that they can then bring to the cell company, the third party in this situation, and request all of the data. That's meta transactional data. So you're talking call logs, times, phone numbers, who's paying for the account, and now CSLI, which is a generic location tracking, as we've covered. And with this data, the Stored Communications Act, you can bring it back and use it to implicate people, as you can see in Carpenter.
So, Counsel, if I interrupt for a moment, is it your argument that the Stored Communication Act itself is unconstitutional on its face?
Parts of it are, sir, in the sense that currently what is going on is without a warrant and without probable cause, a government entity can reach out and take this data. Now, there are arguments to try and validify this using the third-party doctrine, but as you reach into 21st century technology and stuff, old doctrines become, you can't mechanically stretch them over everything.
So let's talk about the third-party doctrine. Because I asked you a question. I asked, is the Stored Communications Act unconstitutional on its face, which would mean it's always unconstitutional? You replied, parts of it, which I think you mean basically as applied to some cases, it might be unconstitutional. So you're not asking us to strike down the entire SCA. You're saying in certain contexts it might be problematic. Tell me, why is it problematic in this case? And or we need to get rid of the law altogether. That's the question for you.
Mm-hmm. One major problem is that only a quarter of Americans express a general understanding of what CSLI data is. And although these are things that technically can be understood by reading through the terms and conditions of your cell provider, with the nature of how revealing this is, it would be irresponsible to just say, oh yeah, you release something to a third party. Now it's public information, because privacy is relational. Just because you want something, you need something to be known by one party doesn't mean it should be automatically disclosed to everyone. Because users of of cell phones acknowledge that they must give up this information to their cell providers in order to participate in using their cell phones, but they still should have an expectation that it remain private, especially to law enforcement.
And to build upon what my partner is saying, and to more directly answer your question from earlier, the principle that we were looking through as far as trying to find a method to still allow law enforcement to use this useful tool to help find and charge criminals, and to make sure that it's not interfering with the everyday lives of the normal American, we looked at the Omnibus Crime Prevention and Safe Streets Act, which is designed to talk about technological data and how it can be collected and stuff. It was originally written in response to abusive wiretaps by the FBI in the late 60s. And since then, it's still applied. They have a principle under Title 3 of this act called minimization. A minimization of a warrant is if someone is calling and you can listen in, and if for the first 5 minutes they don't talk about the crime exactly, like if I call Nick and we're talking about a baseball game from last night, they have to turn it off after 5 minutes. They have to wait a certain amount of time and they can turn it back on. It depends on the exact specifications of the warrant. Also, if I pick up the phone and I say, hello, Dr. So-and-so, or I'm speaking to a priest or an imam or a rabbi, or I'm speaking to my lawyer, they have to turn it off immediately, because those are confidential. That's confidential information that they do not have access to. So what we were looking into as far as a solution for addressing the refinement of the CSLI collection under the Stored Communications Act would be an attempt to minimize the scope of the search, in the sense that this is 127 days, block data, 4 months long, 24/7, 100 points a day, give or take. That's extensive, and there is no way that every single
counselor, you want us to write an opinion. I'm sorry, Justice Silver, please. I think you asked the same question.
I'm going to ask the same question, which is right. So where do we draw the line, right? You said 127 days is too much. So where do we draw the line?
Yes. So looking at, we were speaking about limiting the scope of the search to within hours of the robbery. So if you know very well, like if you look at Terry v. Ohio, which is one of the Fourth Amendment background cases, the police officer in that case noticed that there was people scouting a robbery job they were going to do and stop them. And that was hours before they had planned to do it. So if you were to limit the CSLI collection of these numbers to within the day of the robbery, or a similar time frame as such, you would be speaking a much more reasonable search than what is conducted against Mr. Carpenter here, in the sense that they aren't looking at whether or not he's a subject, whether or not he commits this crime. They're looking at his entire life and trying to put it together. It's essentially a fishing expedition to try and find incriminating evidence on Mr. Carpenter that is not limited in scope and is extensively invasive based on the scale.
I want to go back a little bit. Why did the police in this case end up using the CSLI data in the first place? How did they end up there?
Can you hear me?
Yes, can you hear me?
Hang on one sec. Yes, you're good.
Okay.
And you have about a minute left. I'll give you some more time. You have about a minute left.
Yeah. I just want to understand. You might have mentioned this when you were talking about the facts of the case, but how did the police end up searching the CSLI data in the first place? Right? They didn't just start doing it for no reason. Right?
Yes. No, they were an accomplice in the crime had confessed that this man may have done it, so they tracked it through there. And to wrap up our argument, in the sense, the third-party doctrine will they try and say that the third-party doctrine justifies this because you're giving this information to a third party, therefore you lose any vested privacy interest in it. And looking through otherwise laws and recognized principles, you have HIPAA, which is the Health Insurance Portability and Accessibility Act, as well as client attorney privilege. These are things where you're turning over confidential information to a third party, and if the government wants it, they need a warrant. And in this case, there is no warrant. There's the Stored Communications Act and a court order. And anything short of that for this quantity of information that is invasive is very unconstitutional and goes against the exact wording and spirit of the Fourth Amendment in its entirety.
And to add on to James.
And counsel, you're out of time. You can finish your sentence.
To add on to James, allowing the warrantless collection of CSLI data would be vastly imbalanced in favor of law enforcement because just by using your cell phone in ordinary ways, you give up very sensitive information that could be used against you.
Very good long sentence. Thank you, Counselor.
Thank you.
Thank you, Your Honor.
All right. If the respondent's ready, you can switch positions. Okay, counselors. You'll have 15 minutes. You begin whenever you're ready.
Okay. Let's start with an overview of the case. In April of 2011, police arrested 4 men in connection with a series of armed robberies. One of the men confessed to the crimes and gave the FBI his cell phone number and the numbers of the other participants. The FBI used this information to apply for 3 orders of magistrate judges to abstain transactional records for each of the phone numbers, which the judges granted under the Stored Communications Act. This act provided that the government may require the disclosure of certain telecommunications record when specific and articulable facts show that there has been reasonable grounds to believe that the contents of a wire electronic communication or the records of other information sought are relevant and material to an ongoing criminal investigation. The transactional records obtained by the government include the date and the time of calls, the approximate location where calls began and ended on their connections to cell phone towers or cell site information. The United States did not violate the Fourth Amendment because of the obtaining of cell site location data, or CSLI, by wireless carriers are records of the cell towers our phones connect to every time they try to send and receive calls, texts, emails, and other information. The records generated hundreds and sometimes thousands of times per day include the precise GPS coordinates of each tower, as well as when the phone tried to connect to it. While this may sound complicated, the important points is that in a case like this one, the government argues that CSLI is just a proxy for where the phone, and by extension, the phone's owner, is or has been connected.
Obtaining cell phone location information by the FBI does not constitute a search or seizure under the Fourth Amendment. By signing a contractual agreement with its cell data carrier, T-Mobile, the petitioner gave consent for it to carry out the things which enumerates in its privacy policy, which is, quote, "We may disclose personal information and other information about you or your communications where we have a good faith belief that access, use, preservation, or disclosure of such information is reasonably necessary," end quote. Therefore, his argument does not satisfy the requirements of the two-pronged test laid out in Katz v. U.S. because there cannot be an actual expectation of privacy for information which has been legally forfeited to the data carrier, and because this expectation is certainly not one that society is prepared to recognize as reasonable.
So Counselor, if I can interrupt, I've had a cell phone for years. I've never once read the contract. I suspect you have a cell phone, and your parents have cell phones. I'd be willing to wager that you've never read those little fine print. Is it actually objectively reasonable to think that people don't know this information is being transmitted? I mean, is this a reasonable expectation under Katz?
It is reasonable because as the court talked about in Smith v. Maryland, though you may not read the contract, when you, for example, the pen register they placed on Smith's phone, he cannot claim that he has no idea that his cell phone provider records the numbers that he's dialed, because when you see your bill, for example, it shows you the length of the calls and the reason, certain reasons for the amount that you have to pay for your bill, and anyone in the appellate court case, they noted that anyone, when they're looking at the signal at the top left hand side of the screen, because it fluctuates frequently. So obviously that when you're, for example, moving on a public road and it's fluctuating, you know that you're establishing connection with many different towers, and in an increasingly digitalized world, the citizen has kind of an obligation to understand that your cell phone provider does know these things about you and does know your approximate location, because you have to make these connections with the cell towers.
So, Counselor, there's some survey data that exists which shows that, as a general matter, most people who use cell phones don't know this information being transmitted, right? When you dial a phone number, you know that you've made a call. When you send a text message to a person, you know you've made a call. When you Snapchat a person, you know you've sent them messages. But the cell phone data here is being done passively by merely turning on your phone and moving from place A to place B. It's being transmitted whether you do anything or not. You just turn on your phone. Is this case distinguishable from Smith v. Maryland?
The idea that you have no real control over where your cell phone location data is going is kind of is invalid, because you at any moment you have the choice to turn off your cellular data, and by that, if they only knew his approximate location because of the phone calls that he was making, and so if he just had abstained from making calls on that phone, if he hadn't been using cellular data instead of just Wi-Fi to make text messages, they wouldn't have known his location.
Counselor, but to interrupt, it's not just if he's choosing to make a call. It would also be if someone called him, correct? Or someone texted him.
Correct. You're right. So that was a mistake. But you could always turn your cellular data off. And anyway, even if you're not fully aware of what they are doing, you have a legal obligation when you sign on that dotted line that you have read and understand the agreement. So the idea that just because a high percentage of Americans don't fully know what the capabilities of the cell data carrier are, they still sign that agreement. They still have that legal obligation.
Yes, ignorance has never, unfortunately, been a plea before the law. So the user was conscious of the T-Mobile data, even if the T-Mobile record, even if he never had officially read it himself. For example, if a driver was driving in a 55 speed limit zone, but he never saw the speed limit sign and was driving 80 miles an hour, he could not claim that he hadn't saw the sign. There is no claim to ignorance under the law.
Counselor, your friends on the other side talk about the Jones case. How should the Jones case inform our decision here?
As Antonin Scalia noted in his majority opinion, the only reason that Jones had that it was considered a search under the Fourth Amendment, what the government officials did, is the actual physical trespass of the vehicle when they placed that GPS tracker on the underside of his Jeep. The fact that they knew his exact location of throughout that investigation wasn't important to the Fourth Amendment adjudication. So only the physical putting of the installment of the device, which was the search, was important in that case. So even if the cell site location data was more specific, it still couldn't be considered a search.
So if we could back up just a little bit to go over the US v. Jones case, which is where a law enforcement attached a tracker to Jones' Jeep without judicial approval of any sort. Jones was in clear violation of the Fourth Amendment, with which we concur. Jones had expectation of privacy in his vehicle, and the contract of sale for his Jeep contained no notice of tracking. However, the phone service contract bought by Carpenter clearly in writing sets the bar at good faith and reasonably necessary for the phone company to reveal personal information. The FBI went above and beyond to follow the language in this contract when they secured a court order on reasonable grounds in order to comply with the Stored Communications Act.
Well, Counsel, let me ask you the same question I asked my colleague, or ask your friend on the other side. The Stored Communications Act is a very old statute. It's been around for some time, and technology has evolved at a fairly rapid pace. Could it be that now, based on how technology operates, the the standard put forward in the SCA is no longer reasonable for purposes of the Fourth Amendment. Is that what we should consider?
Completely, but we feel like this isn't exactly a specific part of this case and what's being debated. Just to reiterate, Carpenter, unlike Jones, was informed that a binding contract of its company's ability to collect and disclose data if they had good faith, which is a very loose term, disclosure is reasonably necessary. The FBI secured such data by obtaining a court order from a judge who recognized the reasonable grounds upon which this was granted, firmly within the mandate of the SCA, which is constitutionally the law of the land. The question,
but that's our question, though. You're assuming the question. What if we're saying that the process provided by the SCA is not consistent with the Fourth Amendment? Let me ask you this question. Why couldn't the government just get a warrant? If they went to a judge for the Stored Communications Act application, why couldn't they just get a warrant?
Because a warrant wasn't necessary. The third party doctrine dictates that someone who submits their information to a third party has no expectation of privacy.
No, I get that you say it's not necessary, but if this court rules it is necessary, that changes the rule, right? So why shouldn't he have just gotten a warrant? Why can't, if you're already going to a judge to apply for one of these applications, what's the additional burden on government to seek a warrant? Is it that much of a difference?
Well, if they had had to seek for a warrant, they would have had to provide a specific thing that they were searching for.
And that's exactly the problem. As your friends on the other side noted, they were requesting 127 days. They called it a fishing expedition on the other side. Are your friends wrong about that? Did the police know what they were looking for here?
No, but if it gets to that, then the central argument of theirs is that the Stored Communications Act is itself unconstitutional, and there haven't been any legal challenges to that law. So we shouldn't doubt the Stored Communications Act if it's still a legally binding.
But that's what this case is. Your friends argue that as applied to this search, the Stored Communications Act violated the Fourth Amendment, and so that's my question to you. You said a minute ago you didn't know what you were looking for, and that's probably right. But doesn't that mean you have like a general warrant that existed back in the days of the 13 colonies, where the king would issue these writs of assistance to search anything they wanted? Why is that not like a general warrant?
It's fundamentally different. It's not like the GPS tracking in Jones. And I think I want to refute something that our colleague said. They said that since the time of the crime, there have been much more cell towers constructed so that if they know which cell tower you're making connection with, they know about within 200 feet. I'd like to refute that. In the appellate hearing, which is in 2015, FBI agent Christopher Hess testified that in Detroit, in a very urbanized area, the towers had a radius of from a half a mile to 2 mile radius. And in Detroit, obviously, you have buildings within that radius. So even if you know which cell tower someone's making connection with, there's still hundreds of buildings you don't know anything like their exact location. So I would just dispute what they said is factually inaccurate.
Counselor, can I ask you a question though? Where do we draw the line, right? So you don't think 127 days is too much. So can I just track somebody for 3 years?
There was even though it was an extended period of time, we have to look back to the basis of the case, and that the time isn't really relevant compared to the original opinions established back where it's clearly stated in the T-Mobile policy when we go back, and how it reserves the right, even though that it may have taken an overreaching long period of time.
It's not reasonably, you can't expect to be reasonably private. So I'd argue there is no line because it's not their private information anymore.
Right. So we can track. So police should be able to track as long as they want, because your argument is once you've signed that contract, you have no expectation of privacy.
Yeah, you made
the data ever.
You made the tacit choice or decision to submit that information. You could instead of signing to the T-Mobile policy, you could have gone to a different data carrier such as Verizon or AT&T that might have a different policy, or you could not just turn off the cellular data, as I said previously. But as Justice John Holland said in his Katz decision, quote, "A man's home is for most purposes a place where we expect privacy, but objects, activities, or statements that he exposes to the plain view of outsiders are not protected because no intention to keep them to himself has been exhibited." So the location data, I mean, it's basically the same as driving a vehicle through a public thoroughfare. It can't reasonably be considered private.
Well, but again, the CATS test has two elements, right? Whether it's a subjective expectation of privacy and objective. Subjectively, CATS had no idea, and objectively, as a matter of population, people don't know this, right? So you keep signing the contract, which is fine, but this is not a matter of contract law. It's what's objectively reasonable. And what if we disagree with you about the contract? What's your backup argument about why this is still a reasonable? Why it would be not a reasonable expectation of privacy?
Well, in the CATS argument, even though the number dialed and the contents of the phone conversation passed through a third party, the content of the phone call is not turned over in the same way that the telephone number dialed is. And CATS itself recognizes that the Fourth Amendment protections for the content of the conversation are not diminished simply because the content passes through the third party phone company.
Yeah, well, if we look at Smith v. Maryland, Michael E. Smith argued that he didn't know that the or that when he was making calls, that the cell phone company could turn over his phone number that he was dialing. He made that argument, and they disagreed with it. So we can only look to precedent in CATS v. U.S.
But Counselor, you're getting something more than just who you're calling, right? The phone number that you're calling. You're getting location data, right?
Yeah, but the underlying argument is the same in that you can't claim just because you don't know what you're giving over, you don't have an expectation of privacy.
So let me ask you, Counselor, do you own a cell phone?
Yes.
Do you use a cell phone?
Mm-hmm.
When you're driving around, do you suspect that the government is tracking your whereabouts just because you have that cell phone?
I mean, I think if they had reasonable grounds to suspect that my cell phone location data was relevant to criminal investigation, then yes.
But you're saying, so let me try to understand the test, right? Because they can track as long as they want.
About
right?
30 seconds left.
Now, if that's only if they have reasonable suspicion that you've committed a crime, or they can track whenever they want, whenever. I'm trying to understand the standard you want us to have here to apply.
So I just think you have to obviously act lawfully pursuant to the Stored Communications Act. They had applied for the transactional records to the magistrate judges. They received permission to do so. And so I think once you've received that permission by the magistrate judge, then yes, you should have indefinite ability to track someone's approximate whereabouts.
Okay.
Okay, you have 5 seconds left. We'll leave it there. Thank you, counsel. All right, there it is. We go back now for 5 minutes of rebuttal time from the petitioner, and you begin whenever you're ready.
We're ready.
Okay, we begin.
Your Honor, on December 15th, 1791, the Fourth Amendment of the United States Constitution was ratified, stating that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. It is a sad occurrence that today this very right is being violated in this case.
So the respondents talked about Jones saying that only the physical trespass contributed to the unconstitutionality. However, the decision in Jones did note the fact that the length of a search would affect how valid it is and what legal scrutiny you would need to be able to violate a person's individual rights. And considering the fact that 127 days worth of data was collected, the length of the search would definitely classify as long-term, and reasonable suspicion would not be enough or clear and articulable facts.
Furthermore, the opposing counsel said that this CSLI and other transactional data was on reasonable grounds. The Stored Communications Act asks for clear and articulate facts that it may aid in an ongoing investigation. The language in that suggests that it might be able to help this general information that they're pulling, in the sense that if they look at one cell tower and they see within an hour of a crime and they see all of these phone numbers have used this, well, looking at the CSLI for 4 to 6 months may indicate that person in some criminal investigation. So that's a pretty clear and articulate fact that they can just go through it using what the FBI tried to use in Carpenter, because it might help in that ongoing investigation. And that's not the protections that we're guaranteed in the Fourth Amendment. We're guaranteed probable cause before there is any sort of search or seizure. And this is inherently a search of confidential information. And it's not on reasonable grounds, and clear and articulable facts is not even close to reasonable suspicion, which is the lowest bar for Fourth Amendment.
Counselor, let me ask you a question. Your friends on the other side made a lot of focused quite a bit on the contract. They said that they signed on the dotted line. Why should that not resolve the inquiry? Why is that not enough? If they sign their contract, they should know they're sharing data, good faith. And what? Tell me why that's the argument's not dispositive.
Because if you want to use a cell phone, which is necessary in today's society, you don't have control over where your cell data is going. The court should understand that using the service of cell providers is an unavoidable part of using a cell phone.
Yeah, this is very similar to what's seen in the HIPAA and the client attorney privilege. These are, going to a doctor is something that all humans need to do in order to maintain a good state of health. And they needed to create a law to make sure that by going to the doctor, you aren't going to give away anything that's excessively personal, which is why they have HIPAA. So now a doctor can be charged criminally if they're giving away information about their clients that is undue and unjust. And it is this exact sense that we're seeing in this case. There is confidential information, like your general location, that's being given away. The opposing counsel stated, well, you can just turn off your cellular data and you'll be all set. But in reality, in order to operate as an American adult, like I was saying earlier, 94% of American adults have a cell phone. If you were to turn off your cellular data and just go off the grid, you're missing out on what makes your life your life. You can't call your family. You can't get calls from your
counselor. If this is such a big problem that Americans will agree on, why should it be for the courts to fix this? Why can't Congress modify it? Sorry, can you hear me now?
Yes. Could you repeat the question?
Yeah, I'll repeat the question. No problem. If this is such a serious problem on which all people agree, why should it be for the courts to fix this? Why can't Congress amend the Stored Communications Act to require a warrant before such a cell phone data search is conducted? Let for Congress to fix. Why do we have to fix this?
Well, what would happen is if the court rules in favor of Mr. Carpenter in this case, it would be followed up with legislation to defend this, because right now the court is faced with a decision that protects
or Congress could do nothing and the police can get a damn warrant. Right? Can't the police just get a warrant? Wouldn't that be the other answer? My point is, what if we say that this search was reasonable, but if Congress wants to fix it, they can? Why is that? Why can't that not be the answer?
Because right now, in this very case and other ones like it, there are rights being violated. Your Fourth Amendment, if you are under investigation in one of these cases, your basic rights guaranteed to you in the Bill of Rights are being violated. And if we want to stand idly and sit on our hands while this injustice occurs, we can do that. Or we can try and stand up for the values that James Madison wrote down, the values that our founding fathers stood for when they wrote this. The Fourth Amendment, James Otis, this is against general warrants, which is exactly what this is. As the opposing counsel stated, it may have taken an overreaching amount of time, but this is a general warrant for 4 months. There is no.
You're out of time, counsel. You can finish your sentence, please.
Yep. There is no expectation of private, there is an expectation to privacy of your affairs over this amount of time, and that is just being thrown out the window with general warrants and fishing expeditions, and the actual Fourth Amendment is being lost in all of this. Thank you, Your Honor.
Thank you very much. I like you string together the end to make a long sentence. Very good. Lots of semicolons, no periods. All right, respondents, you have 5 minutes rebuttal. You can begin whenever you're ready.
Ready? Okay. So the opposing side referenced how CSLI can be used for extremely private, to be found to use extremely advanced and very private details about people. And even though the user was completely conscious, or supposed to be completely conscious through the data, it brings up a safety issue where we can use the CSLI data to possibly track people for good, not only for bad. There's been countless lives saved where investigators need to use even such tasks as Find My iPhone, which is very popular now, or other location information which can be tracked to find people and use people and convict crimes, or the other way around, save lives.
In addition, we'd like to note that they keep claiming that in this digitized world, it's kind of your civic duty to own a cell phone. That's just false. Many people don't own a cell phone, especially much of the elderly population in the U.S. So the idea that you have no way of escaping this, approximate tracking is not very accurate.
Counselor, if I could ask you something you said a moment ago, I think Justice Silverberg asked if the search was for 2 or 3 years, and you said if a judge signs off on it, that's reasonable. Is there really no limit on how much data can be collected? Is that your position?
There is an eventual time limit that has to be applied. To me, the issue is not 127 days, but more so focusing back on the case, how there's been a written notification that Carpenter had, where when he signs, Metro PCS has the right to use the information, and the government has the right to be used it based on the T-Mobile policy. And even if Carpenter may have unknowingly transmitted the CSLI data because he never read the terms, then
But Counselor, you just said there has to be some time limit. So how do we draw that line, right? So you say 127 days is fine. Why was 127 days fine in this case?
Take it.
I think my colleague made a mistake. We don't think there should be any limit. If it's not reasonably private, as we said before, due to the third-party doctrine, if you have no reasonable expectation of privacy, then there should be no limit.
So once the police suspect that you've committed a crime, they can track you indefinitely.
Yes.
Is that what you're arguing?
Yeah.
So, I mean, there's a problem with your argument. I appreciate as a matter of advocacy, you're trying to take your point, stick to it, because if you deviate from your point, it's like, you're losing your argument. But it's a really hard opinion for the court to write that the police can track you for the rest of your life. Is there any precedent you can use to support that line of reasoning, that argument?
I mean, I know that there have been many cases in which, people have been, like, potential terrorists have been tracked for years, and that has at some point been able to save many lives. So I think certainly maybe the magistrate judge has an obligation in maybe monitoring how long the investigation has gone on for, and maybe can withdraw the permission to use those transactional records at a certain time if no concrete evidence has been gathered. So perhaps the FBI has a duty maybe every 6 months to supply the magistrate judge with some evidence that the transactional records are relevant to the investigation, to sort of renew the application to use those transactional records.
But is that because at 6 months it's no longer a reasonable search? In other words, why 6 months? Is there a line at which becomes unreasonable? That's my question for you.
There's no line at which it becomes unreasonable. The third-party doctrine will always hold, but if you're tracking someone, even if there's reasonable grounds to suspect that they're involved, those reasonable grounds may sort of decline in value if there hasn't been any recurring suspicion.
What information, though? So this is what your colleagues on the other side said. Really, all the police need is the CSLI data within 24 hours of the crime, right? So why do they need 127 days? Why would they need 6 months? Why would they need 2 or 3 years, right? Doesn't that factor into the reasonableness aspect of this?
Well, I think often you can look at someone's past movements, but not outside of the just 24 hours next to where they committed the crime, and often that can be telling. So if, for example, it wasn't if outside the 24-hour area, if they found that he had been meeting with some of the other accomplices, not necessarily like next to the Radio Shack.
Sorry, Counsel, you're off time. I forgot to announce it. My apologies. If you want to take another 10 seconds to wrap up, you can.
Yeah, so like outside the 24 area, maybe like 3 months before or after, if they had found that all the accomplices had been meeting very suspiciously in a certain location, maybe not next to the site where they had actually stolen from the Radio Shack, that might be helpful. So I disagree with the notion that it's only the 24 hours after you've committed the crime that is relevant to the investigation.
Okay.
Thank you.
Thank you very much, Counselor. And that brings the third match of the Harlan Institute Consorts Virtual Supreme Court to an end. I'd like to thank both of the teams who did a wonderful job. You always make us proud that the future of our polity has such young and committed civic citizens who are willing to think about the Constitution. We'll be holding several more rounds, and we'll be announcing the winner at the end of this month, if we'll be advancing to the championship round. And I thank you very much for your attention. Julie?
Yep, I just want to reiterate Josh's note that you both teams did a really wonderful job. And the final round will be hosted in Washington, D.C. at Georgetown University Law Center on April 26th. And like Josh said, we will let you know by the end of this month whether or not you will be advancing to the championship round. Congrats again.
Congratulations to both teams, and the court is adjourned